Yeah, so this recording webinar is being recorded. So we do have our first part already on our website. And after this training, this will be up as well. So in our website, I will send a follow-up email after this training where I will be providing the PowerPoint slides and our QR codes. So if you are tuning in via a mobile device, do not worry, you'll get that QR code so you can scan later. Just make sure to get your COE words in. Um, All right, I think we can get started. So thank you everyone for joining us for this comprehensive overview of SIJS Part 2 training, where we'll be touching base on the I-360 and I-485 forms. And that's just after getting that predicate order, which is essential in the first part. So thank you everybody who's joining and for sharing the word. We're super excited that you're here to learn and we're here to teach. So again, this webinar is being recorded for training and educational purposes. So if you ever need to reference back to it, it will be on our website. Um, let's see. All right. So my name is Berenice Sanchez Ruiz, and I am the SIJS Pro Bono Coordinator here with the Non-Detained Kids team at NIJC. And with me is our rock star, Hillary Richardson, who is our managing attorney. And we wouldn't be able to do this program without her. So we're super grateful that we have her here and she'll be presenting. So yeah, I'll just pass it to Hillary once we get more participants and we should be good to go.
Thanks so much, Berenice, and good morning, everyone. Thank you all for joining. I think we can go ahead and get started. I'm just going to briefly do a little pitch about NIJC, which is on our next slide, and we will review the agenda, and then we'll make sure that we get your attendance marked. So NIJC, for those who may not be familiar, I know there's a lot of local folks and some national folks on the call. We're a national organization. We provide legal services and impact litigation and policy work on behalf of immigrants across the country. And our project on NIJC, the Non-Detained Kids team, has for a number of years focused a great deal on Special Immigrant Juvenile Status. So that's what we'll be talking about today. As Berenice mentioned, we have a case list and we're also open for questions. We've got a lot of resources on our website. So we really encourage you to use this as a resource, as this is a really important form of immigration relief that protects kids. So we really encourage everyone to do these cases. They are not difficult. And today we're going to be talking about the immigration piece of that case. If you have questions about the state court piece, as Berenice said, please go ahead and refer back to our prior training, which is up on our website. So just a brief overview of the agenda, which is on our next slide. We are first going to talk about we're just going to give a brief overview of SIJS for those who may have missed the last training, and then we'll go straight into filing our forms. We'll talk about the I-360. We'll talk about the backlog, which means you will not be able to file Form I-485 or your adjustment application right away, but you may have kids you find who are currently eligible for adjustment, and we'll talk about that. We have saved time for Q&A at the end, but I also encourage you to put your questions in the chat or in the Q&A throughout. I find that it's a good way to keep engagement up to be able to answer those questions in real time wherever possible. I'll try to do that so that we can make sure that folks have their questions answered. And then I think we skipped over our QR code, sorry. So for those who are on the webinar and can scan the attendance code, please go ahead and do so. If you're joining from your phone, don't worry, you will get this link, but I'm going to give you a second to go ahead and do this to make sure you can get your credit for this training. All right, so let's move to our SIJS Refresher. So just as a reminder, Special Immigrant Juvenile Status is available to kids living in the U.S. who are under 21 and unmarried. Before they can apply, they need a predicate order, which we talked about last time. The predicate order has to have been issued by a juvenile court. We talked about all of the different kinds of courts that can meet that definition, and it has to include certain types of magic language. So the court has to have placed them under someone's custody, whether that's a person or an agency. And the court has to have found that the child's reunification with one of their parents or with both of their parents is not viable due to abuse, neglect, abandonment, or a similar basis under state law. And that court also finds that it would not be in their best interest to return to their home country. The last piece here, that the Secretary of Homeland Security consents, just means that they submit the application, and USCIS has the right to approve or deny that application. So that's the baseline. It's found in the INA at 101A27J. I believe in our last presentation, we went over some of the other resources. So both the INA, the federal regulations, and the USCIS policy manual. If you intend on doing this work, I really encourage you to review all of those resources. We do have relatively new SIJS regulations that are really useful as you're working up these cases. So let's talk about our timeline. We are today going to talk about the second step. Our first presentation, our first training talked entirely about the process for getting that predicate order for the juvenile court. But today we're going to be talking about everything that follows. The SIJS petition has to be filed before the child turns 21. This is the case even if you've gotten a predicate order based on the child being under 18. As we mentioned in our previous training, in Illinois, children up to the age of 21 have the right to go to juvenile court and seek a predicate order via a guardianship, a post-18 guardianship. But whether the predicate order was for an under 18 or a post-18 child, you will need to get that SIJS petition in before the child turns 21. If you are looking at a situation where the child is turning 21 relatively urgently, you're going to need to look at a calendar and count back those days to make sure that you understand that the last day that you can overnight their application is essentially 2 days before their birthday. I will also point out that same day filing is now an option. It's a really big pain. So don't do it if you can avoid it. It's been difficult to coordinate with USCIS. But if you are the day before the child's 21st birthday, you can go to USCIS, request an InfoPass appointment, go in with a specific purpose of filing their SIJS petition on that same day, but it still has to be before their 21st birthday. Once that SIJS petition is filed, it can take a few months to approve. We are fortunately these days seeing those approvals come pretty quickly, within a couple of months typically. And then almost all of the approvals that we have seen have included deferred action for our clients. Deferred action is discretionary, and so if you have a client who has some sort of criminal or delinquency history, they may not receive deferred action, but so far we have seen almost everyone receive it, which is really important because it allows our clients to seek a work permit. Then we will be talking about the extensive wait that they will have before they can file for lawful permanent resident status. And I'll go into more detail about what that wait is and why. But once they have been approved for SIJS and their priority date is current, meaning they're eligible to apply, they can file their application for lawful permanent residence or a green card. And if approved, that is the end of the road. That is the goal. The child becomes a lawful permanent resident, all through a process that we found to be really far less traumatizing, for example, than doing an asylum interview or other forms of immigration relief. So we really appreciate this form of relief, both because the path is relatively clear, even though it's a long wait, and it's a good way to help kids and young people in this vulnerable situation in sort of a minimally traumatizing way. So let's move on to the visa bulletin. I will talk about this again later on, but the visa bulletin is really important for you right now if you have kids who applied for SIJS a long time ago and are now coming to a current priority date. But yeah, we'll talk about the backlog in a little bit. Youth who are eligible for SIJS can apply for a green card once their priority date is current. Those visas are coming from the employment-based fourth preference category. Right now, that is at January of 2021 for final action dates. As of October, if kids have priority dates prior to February of 2021, they will be able to submit their applications, but they will not be able to be adjudicated until the visa bulletin moves. This is the case because there's a limit on the number of people per country who can get a green card through this preference category in any given fiscal year. All right. We have already come to our first CLE word, which is status. Please go ahead and write that down. All right. So we're going to go back to our three-step process for filing the Form I-360. Just as a little overview, we talked about last time getting that predicate order, then filing the SIJS petition itself, and then the final step being filing your adjustment of status application. So right now we are going to talk about that Form I-360. That's the SIJS petition itself. So we're using Form I-360. This is a petition that's used for multiple different types of applications, multiple different types of relief. So we're going to go over which parts are applicable to SIJS. This is currently, I believe, still 19 pages. Like I said, not everything pertains to SIJS. The other thing that I want to flag is that this form is updated, like all USCIS forms, relatively regularly and without much warning. So you will want to make sure that you're looking at USCIS's website to get the most recent edition before you start filling this out. As I mentioned before, this form must be filed before the child turns 21. So the last day that this form can be filed with USCIS is the day before their 21st birthday. Additionally, something to keep in mind with urgent cases is you should make sure that your client is still eligible at the time that you file. Since you've been through this long predicate order process before, you want to call your client, review the form with them, and make sure, for example, they're still unmarried. And if it's relevant that they're still living with their guardian, because the form will ask if they are still living in their court-ordered placement. We'll review the specific answers to that question. There are some reasons that the client may answer no to that question, and that will still be fine. All right, so this is the beginning of Form I-360, and we're just going to go over this form piece by piece so that it's very clear what the expectations are. The first question that we typically get questions or concerns about is current non-immigrant status. We will typically recommend saying SIJS petitioner if the client has no other status. But for those immigration attorneys out there who are familiar, there may be multiple types of status that an individual has at that point. So just make sure that you're putting something in there. It is fine to say no status if the client has no status, but we found that this is one of the clearest ways to respond. Then also on, I believe, page 3, the form asks for the client's last address in their home country. We often don't have exact information for this section, and so it is fine to just put the city and country, the neighborhood city and country, if we have that information. But do make sure that you're paying attention to what the instructions ask, because it is in the address section, but it is specific to their home country. We will also not need to answer the question about working without authorization. We'll talk a little bit more about admissibility and waivers for special immigrant juveniles, but this is not applicable to them, fortunately, and so we don't even need to answer that question. And then a couple of other just general overviews before we get further into the form. The form only allows for one box to be selected as to why reunification with a parent is not viable. But if your predicate order, for example, has found that the child's reunification is not viable because of there was abuse and abandonment or abuse, abandonment, and neglect, you will want to make sure that you're checking off all of those boxes. Again, immigration attorneys are familiar with the fact that the forms are not easily fillable, so you may need to print out and manually check those boxes. And then finally, another place that we found often confusing language is on page 9, where they ask if the child is now or has ever been in the custody of the Department of Health and Human Services. Basically, what that means is, has the child ever been designated an unaccompanied minor? Because that is how they would be in the custody of the Office of Refugee Resettlement. So if you know that about your child, go ahead and mark yes for that question. All right. So I mentioned at the beginning that there are regulations and other legal resources that it will be important for you to be reviewing as you're working up the case. One relatively recent development is the SIJS final rule, which was super welcome because before that it had been over a decade since there were any new rules issued. We advocates generally welcomed the new rule. It was generally positive. There were some changes that we had hoped to make that that the government chose not to include. But overall, I think it clarified quite well some of the points of tension that advocates had seen when USCIS was processing these cases. So, for example, USCIS is not supposed to go behind the predicate order. The juvenile court issuing the predicate order with the special findings of abuse, abandonment, and neglect based on the child's best interest is the one with the expertise to make those decisions. And so at NIJC, if we do occasionally get RFEs, requests for evidence from USCIS, saying we don't understand why the court made this decision, and they'll ask for additional evidence. Depending on how the order was worded, we'll adjust our response, but we do always come back to this now codified statement that USCIS is expected to defer to the juvenile court. If the juvenile court has said so, USCIS cannot second guess that. Another really important point that was codified in this final rule, previously, I think we would often see questioning of the predicate order itself. It was an odd sort of catch-22, right? Like the child obviously went and tried to get the predicate order because that would make them eligible for immigration relief. But there was this sense that you were not supposed to talk about how it made the child eligible for immigration relief, and there had to be some other reason. Like USCIS policy said that we expect that you're seeking this order in order to seek relief from your parental maltreatment rather than just for immigration purposes. And this final rule clarified that the relief from parental maltreatment can include the order itself. I think that's really important because it was an odd place. It was an unfair place for USCIS to put children, right? That they had to go and get this order, but they had to act like it wasn't for immigration purposes. We did, and we still do try to be very careful about not including language in the predicate order that says, this child is only here for immigration reasons, because there are almost always other benefits to getting a custody or guardianship order. But the clarification from that final rule has been helpful, in my opinion, for advocates as we're working through these cases. All right. So this is what an I-360 approval notice looks like. So typically, we fill out our application, or we fill out our petition, we file it before the child turns 21. And if everything looks good, we will get an approval notice. This is what it looks like. And it includes deferred action. So if you look in the middle of this petition, it's in tiny letters, essentially, it says USCIS has approved the above petition, and there's a grant of deferred action. If you get this kind of approval notice, what that means is that you will now be able to seek an EAD, a work permit on this basis. And actually, as I'm looking through this, I think that we skipped a step. Can we go back one? Because there should be one that says documents to prepare right before the SIJS regulations. There we go. Okay, I knew we had skipped straight to approval for some reason. All right, so among the documents that you need to prepare in order to get this approval notice, you'll want to have a cover letter explaining your child's eligibility for SIJS. We try to keep these super minimal, to be perfectly honest. The predicate order itself is essentially the evidence that the child is eligible. We don't do extensive arguments unless we believe that there's special circumstances, such as a delinquency history or other questions about the child's eligibility. But typically we'll cite to the regulations, we'll provide a short statement about the child, their age, who they live with, the type of harm they experience, and the fact that a predicate order was entered. And we do, I believe, have sample cover letters available if folks are looking for a template. You'll want to include your G28 as the attorney or representative. You'll want a copy of the predicate order. The predicate order itself needs to have been entered by the court. But we've gotten questions before about certified copies. I think that's less of an issue now that that most things are submitted electronically. Essentially, any printout from the court's docket that establishes that the judge signed and entered the order on X date is an appropriate copy to submit. You'll also want to submit evidence of the client's identity. Usually for our kids, they'll have a birth certificate. We need to include a certified English translation of that birth certificate. And if they are a former unaccompanied child, which is a large portion of our clients, will include a copy of the ORR verification of release. That's the face sheet that the children get when they're released from ORR custody. And that acts as a government issued photo ID, as well as evidence of the child's physical presence in the United States. If the child does not have any form of government issued photo ID, that should still be fine. You can establish their identity with the birth certificate and their physical presence and identity with the predicate order itself, which is issued by a court that establishes that the child is here and subject to that court's jurisdiction. So those are the basic documents. We do not submit anything else. We do not submit copies of the entire court file from the predicate order, affidavits, anything else with that document. We are never trying to raise the bar with USCIS. We are trying to make sure that we submit sufficient documentation to get this approved for our clients. And I think I will stop here for a minute because this is just about all we have in terms of the I-360 itself. Do we have any questions? Oh, here, I see one that says a priority date for the visa bulletin based on the date of filing or date of approval. This is a very good question. This is based on the date of filing. So even if USCIS takes a long time, which they have in the past to approve, you'll be looking at the date of filing. You will also, once you file your I-360 petition, you'll get your receipt notice and it will say the priority date on it. So that's the date you should be operating from. Do we have any other questions at this point about the I-360 filing? Is the birth certificate required? So we have occasionally had clients who don't have a birth certificate for whatever reason, right? And yes, ideally the birth certificate is required. If you don't have a birth certificate, you're going to do kind of the same thing if you're an immigration advocate as you would do in any scenario where you don't have a birth certificate. Ideally, you would get affidavits of identity from the child. If the child is with one parent, the parent can provide an affidavit explaining who the child is, when and where they were born, and why no birth certificate is available, and will continue to, kind of fight that fight with USCIS. We've definitely been able to establish children's identity without it, but it's going to require a little more work and a little more evidence. And you may get an RFE from USCIS asking for more evidence about who the child is. All right, I see a question from Stephanie Martinez. On the I-360, after answering the question about ORR, the following question asks whether the court order has changed that. Yes, so On the I-360 itself, it asks whether the court order has changed your custody. That refers to something called specific consent. So if a child is seeking SIJS while they are detained, while they're in custody of the Office of Refugee Resettlement, um, if the court issuing the predicate order changes that placement, they actually need to seek specific consent from the government to do so. We don't do a ton of detained SIJS work here in Illinois. We are hoping to change that depending on our relationships with the service providers who particularly see the kids in long-term foster care. But I know that in other states, people do detained SIJS work. For the most part, if your child is not currently in ORR custody, this is not applicable to you. So once you answer the question about ORR, the court has not changed their custody. And then working practitioners access the verification of release if the family does not have a copy. So more questions about detained work, right? The verification of release is part of the child's record with ORR. So the child, you can seek a records request on behalf of the child. NIJC, along with other legal service providers, is we provide direct services to kids while they're detained. And so we have access to some of those documents, particularly the verification of release sheet right away. If you as a practitioner are not part of a legal service provider serving kids while they're detained, you will need to do a records request. And I think the form is now called A5, but you can look up the form used to seek that record. However, I do want to point out that sheet is not required, right? SIJS is available to accompanied and unaccompanied kids. And so you can establish their identity without that sheet if it's not available. She asks, at what point does the physical presence clock start? So there is no clock here. There's not a physical presence requirement that is time-based. If the kid arrived yesterday, if the kid arrived, 15 years ago, it's not a specific time. It simply means that a child cannot apply for SIJS from outside of the country. Now, depending on the type of court you're going before, there may be a requirement that the child have lived in the venue that court is for a certain amount of time in order for the court to have jurisdiction. I think we addressed that to some extent in the prior training about predicate orders. All right. I'm glad to see all of these very good questions. So let's go back to where are we at? So approval of Form I-360. So a couple slides forward. This is our approval notice. And if we can go to the next slide. So approvals are currently taking, honestly, I would say approvals are taking even less than 6 months a lot of times. I will point out that the regulations state that the SIJS petition must be adjudicated within 180 days. And prior to a couple of years ago, we were seeing USCIS constantly far overstep that timeline. It was taking sometimes years to get these approved. But more recently, whether that is because of more resources or litigation, the approvals are happening for the most part under 6 months. Once the child has an approved I-360, they have Special Immigrant Juvenile Status, which is wonderful. But that is not really a permanent status. It is simply essentially approval of a visa number so that they can eventually adjust to the status of lawful permanent resident. But a relatively new development since about 2 years ago is deferred action, which I mentioned. So that means once a child has Special Immigrant Juvenile Status, they are also eligible for deferred action, which is slightly more protection. It is also not a permanent status, but it does give official protection from removal, and it provides that really essential eligibility for work authorization. I want to point out as well, it says no fee here. There is now no fee for any part of the SIJS process. So anything related to SIJS from I-360 to I-765 to the adjustment application, none of that should have any related fees. And that is by USCIS policy as of, I believe, this year. their new fee rules. Okay. And so we've already mentioned deferred action. They can apply for a work permit immediately. I want to point out that even younger kids, we typically will apply for a work permit for them, even if they're far too young to work, because it is just never going to hurt them to have a government issued photo ID. That tends to be useful in all sorts of scenarios. So we will apply for a work permit for a baby if we can get it. It's helpful generally. All right. And then here's a piece that has been really useful lately. I don't know how many folks on the call are immigration attorneys, but if you are, you may have noticed that there was a final rule on termination of proceedings, termination and administrative closure of removal proceedings that went into effect at the end of July. And one really important piece of that rule specifically lists deferred action as an optional, so a discretionary, not a mandatory basis, but a discretionary basis for an immigration judge to terminate removal proceedings. We are terminating pretty much in every case where it seems appropriate. You will want to assess your individual case if your child is in removal proceedings in case they are consolidated with someone, if they have a court-based application on file, or if they simply prefer to proceed in immigration court. But we have found that almost every case where the child has been approved for SIJS and granted deferred action, we are able to get removal proceedings terminated. We file a motion with the court, we cite to this rule, and we also cite to guidance from the end of last year from both the court and from OPLA, from ICE. Both of them issued guidance, new memos at the end of last year regarding treatment of juveniles and treatment of non-priorities for immigration enforcement. So the combination of this termination rule, deferred action, and that new guidance from the court and from OPLA means that really, if you request termination based on special immigrant juvenile status, they should give it to you. And I will also just note, this is an election year. We don't know what the future holds. And for that reason, we really are trying to get all of those motions terminated sooner rather than later for folks who are eligible and for whom this is appropriate. All right. Do we have additional questions about that? Let me see. Oh, this is a really good question. If a child does not receive deferred action on their I-360 approval, is there a way to request it from USCIS? So the USCIS has been sort of cagey about the answers to this question. I would suggest looking up, if you Google USCIS responses in stakeholder meetings, they gave a relatively straight answer, I believe, in a recent stakeholder meeting earlier this year with the End SIJS Backlog Coalition. And they basically said, as an official matter, a decision on deferred action cannot be appealed. It's final, it's within their discretion. They either do it or they don't. But they also mentioned that anybody at any time can request deferred action from their USCIS field office. So if you don't see a reason that the child shouldn't have received deferred action, you can try that. I haven't heard about the relative success of those, requests, but it's certainly something that you could attempt. If your child doesn't get deferred action and they have some kind of delinquency history, it is probably not worth the time and effort to request deferred action at that point. You want to assess their other, options for protection, because it is as a matter of law, essentially, and policy, deferred action is discretionary and it's not appealable. I have had multiple cases taken off the court's calendar due to the pending I-360. I'm unsure whether I need to file a motion to recalendar or file a motion to terminate. So this is also a good question that we've been doing a lot of strategic motioning up in the court. So for those practicing particularly before the Chicago Immigration Court, it's pretty backed up, pretty chaotic, and lots of cases are taken off the calendar. Our position and what we've had success with is that if a case is off the court's calendar, but it's not formally administratively closed, we've been able to file a motion to terminate without a motion to recalendar. So if you look at your your EOIR portal and it says pending with no future hearing, that's not the same thing as administratively closed. And again, we've been successful simply filing the motions to terminate. I will also point out that um, at least in Chicago, juvenile cases are any cases involving juveniles who are not with an adult, right? So not a consolidated family, but if there's a juvenile in removal on their own and they are under the age of 21, those cases should be, by the court's procedure, assigned to Judge Kreitz on the juvenile docket. If you have a client who is in juvenile removal proceedings on their own and they are assigned to a different judge, what Judge Payton has told us to do is to flag those cases for her because the court is expected to place those on the juvenile docket for adjudication because Judge Kreitz is specifically trained to handle juvenile cases. So we have been filing those motions and then making a request to the court. We'll email Judge Payton and Lynn Hollander and Elizabeth Earlywine, who are the OPLA juvenile docket specialists. And usually that is a good way to get movement on those cases. All right, let me look at our timing. It's 9:30. I think we have time for some more questions. What do you think, Berenice, at this stage?
Yeah, I think we can continue with a few more questions.
Okay. Okay, so I'm responding to these questions. Let's see. Have you had any luck getting a parent's case administratively closed based on a child's SIJS status? This is a good question. I don't know if we've tried this specifically, but it seems worth it. I mean, that OPLA memo talking about non-enforcement priorities, I think take a look at the memos and throw something at the wall and see what sticks. That seems absolutely worth it. All right, can you go back to the last slide for that CFR citation? Was that on our last slide? I will also flag you will be getting these slides after the presentation. So if we skip past something, do not worry, you will receive a copy of the slides. All right, if a child has been issued an NTA that hasn't been filed with the court, has ICE been open to quashing the NTAs? Would you recommend sending a letter to requesting the NTA be quashed? You can certainly try. I think because of the aforementioned chaos and just general backlog, we have not been affirmatively reaching out to ICE necessarily about the NTAs that haven't been filed because we have enough work trying to get ICE or the court to respond to motions and requests for kids who are already in proceedings. We have had success in the past under various circumstances asking ICE to withdraw the NTA altogether. But I think you can certainly give that a try. I will point out we have had a rash of cases recently where the child's NTA has not been filed for many years, and the child has now had SIJS and deferred action for quite a while. And suddenly, like this year, their NTA was filed in court and they now have removal proceedings. So it's not a big deal. We will be filing a whole batch of motions to terminate on that basis, but it's inconvenient. So had we thought about it with that group of kids, we might have submitted a formal request for the whole group a couple of years ago just to see if they would withdraw those NTAs altogether. Okay, is there a different EAD category for someone granted SIJS without deferred action? No, sorry. Deferred action was game-changing for SIJS petitioners because before that, there was nothing. They had nothing. They had SIJS, but they did not have a formal form of deferred action, and they did not have any work authorization eligibility unless they were eligible via another form of relief. And so they were stuck in a years-long backlog with no ability to work. So there is no other category for an SIJS-based work permit. Okay, and Lauren is asking, what if the minor's case is consolidated with a parent and we want to terminate for the minor but not put the parent in the court's crosshairs? They are pending but not administratively closed. Lauren, I think that's a judgment call. It's very fact specific. The process I think would be a motion to sever and terminate. You could attempt trying to terminate both of them, just citing that non-enforcement guidance, and you would have to have a careful conversation about the risks and benefits to the parent and the child. But that is a tricky situation. We definitely have seen that before. We've also seen it before with, for example, we need to reopen an old in absentia removal order for a child, and we know that potentially we could be putting the parent at risk by bringing attention to their old removal order. So working with kids and parents is tricky. It is really important just generally to be doing a fact-based case-by-case inquiry and to be getting informed consent from everybody at every step of the way. All right, so I think we are going to go ahead and move forward with the adjustment of status application. All right, we are now at step 3 in the SIJS process. So we're assuming that many years ago, you got a juvenile court order, you got your SIJS petition approved, and that your priority date, meaning the date that your SIJS petition was filed, is now current. If we're doing this as of today, that means that you filed your SIJS petition before January of 2021. That means now you are eligible to apply for adjustment of status. So this is where we're going to talk about SIJS and the visa bulletin backlogs just briefly. So this is a screenshot of one part of the visa bulletin. The U.S. Department of State issues a certain number of visas in each category, both employment-based and family-based, every month of every year. Different types of visas are subject to different yearly caps. And when those caps are reached too early, what that means is that there is a backlog. The line just gets longer because there are not enough visas at any given year for any given category. For some reason, SIJS, which is essentially a humanitarian form of protection for children, was added to the employment-based fourth preference category in the visa bulletin. I encourage everyone to look up and participate in the work of the End the SIJS Backlog Coalition. They've been doing great work around this. They have really great explainers of the backlog, and they've been doing a lot of advocacy to remove special immigrant juveniles from this preference category altogether. It's a humanitarian form of relief. It should not be subject to these caps, and particularly not the type of caps lumped in with employment-based preferences, right? But for right now, we're working with what we have. So as I said, if your client's priority date is before the date listed in the current month's visa bulletin, they are now eligible to apply for adjustment of status. This screenshot is from, I believe, a couple of months ago. As of right now, the fourth preference category is at January of 2021. All right, how do you find out your priority date? Someone asked this earlier. This is a screenshot of your approval notice, and your priority date is listed on the approval notice. If you do a practice at volume, I highly recommend having some way in your database or your files to have that priority date front and center so that you can be keeping track every month whether those priority dates are current according to the current month's visa bulletin. All right, a couple of important pieces about SIJS-based adjustment of status. This form of adjustment of status does not allow derivatives. So no spouses, no children. This isn't always applicable. Sometimes we're working with really young kids who do not have kids, but as I've mentioned, these visa bulletin backlogs are years and years long, which means our kids are getting older and some of them are having kids, right? Where they were older to begin with, and they may have children born in home country who they would like to include in this application. Unfortunately, unless the immigrant child of the immigrant child is independently eligible for SIJS, they will not be able to proceed via the SIJS process. What we have advised some some parents who are approved for SIJS is that when they become LPRs, they can certainly file a family-based petition for their immigrant child, but that would require, in most cases, consular processing, which is just a long and tricky and expensive process. Another limitation that we see in terms of family members of special immigrant juveniles is something that really needs to be discussed ahead of time. Parents of children who are approved for SIJS can never benefit from that relationship. That means that that child can never file a family petition for either parent, right? Even a non-abusive parent, even after becoming a US citizen, those parents are never eligible for any benefit in immigration law that is related to their relationship to the child. So, for example, if the child becomes U visa eligible, but has already been approved for SIJS, our understanding of this section of the INA is that the parents cannot be derivatives as derivative U visas either. No family petition, no derivative anything, because there cannot be anything based on that relationship to the child. If the parent becomes independently eligible for some other form of immigration relief, that's fine. But we do need to be very clear, because I think sometimes those expectations are there, that the child will receive status and then be able to petition for their parent, and that is not going to be possible. All right. So going a little bit into SIJS-based adjustment of status, like any adjustment of status in the United States, it requires a lawful admission or parole. We are more recently seeing recently arrived folks who sometimes are paroled in, right? And that would constitute an appropriate form of parole. If, for example, the child who's SIJS eligible came on a tourist visa or a student visa and simply overstayed, that's a lawful admission that would allow them to adjust. But fortunately for everyone else, SIJS itself acts as a form of parole. And so if someone has been approved for SIJS, once they are eligible to adjust, they are automatically considered to be paroled in, and so it will not be necessary for them to seek a waiver of inadmissibility on that basis. But they are subject to many other grounds of admissibility. So at the time of filing for adjustment of status, you will need to do a full admissibility screen of the individual to make sure that they are in fact eligible. That being said, SIJS has very generous both waivers and exemptions. There are a bunch of grounds of inadmissibility that are not applicable to special immigrant juveniles or waivable. So, for example, almost all of these immigration violations simply don't apply. Unlawful presence, present without admission of parole, entry without documents. Public charge is a big one that is not applicable. So you don't even need to fill out the section on public charge. You simply check no to the box about whether it applies to you. And smuggling. Now, if the child has pretty much any police contact, right? As an immigration practitioner, if I see an individual with any police contact whatsoever, I have a big red flag, I stop, I do a full analysis before taking any further steps, right? And sometimes that means that it affects their admissibility and sometimes it doesn't. But just as a matter of practice, make sure that you are asking the right questions and you're asking the questions in a bunch of different ways, especially with kids and young people. But I think just about with anybody, right? It's not enough to say, have you ever been arrested? I'm going to follow that up with, have you ever been stopped by the police? Have you ever been stopped by the police in a car? Have you ever been stopped by the police in your house? Have you ever been put in the back of a police car? Have the police ever come to your house? Have you ever had to go to court? Because people do not understand what it means to be arrested. They do not understand the difference between being arrested and being convicted. I've had people tell me that they were not arrested because they went to court and paid their fine and now everything is fine, right? And that's understandable. Our criminal legal system is probably even more chaotic and difficult to understand than the immigration system. But it does mean we have a responsibility as advocates to do our best to get information, especially from kids and young people. Um, Juvenile delinquency, however, is not criminal. All right. Matter of Devison states that juvenile delinquency adjudications do not constitute criminal convictions. And we've extended our arguments on that basis to say arrests for juvenile delinquency, essentially arrests that would result in something like a juvenile delinquency adjudication instead of something that they could be criminally convicted for, means that that is not a criminal arrest. So if you have a general question, right, because the I-485 asks a lot of questions about both acts and convictions and arrests. So you will need to answer those truthfully, but I really encourage you to look carefully at the wording of the question itself, because if it says if you have ever been arrested for a crime and your child has been arrested for a juvenile delinquency act, our argument would be, well, they haven't been arrested for a crime, right? But that being said, there are a lot of other questions. Have you ever been arrested or detained for any reason whatsoever? You're gonna have to answer yes, probably, to that, even if they've had immigration contact, and we'll go into that. But I think it's really important to keep in mind, particularly if your child has a number of encounters with the police as a juvenile, to really be clear, make your criminal history chart so you understand which arrest uh, concords with which adjudication, so that you're not admitting something that you shouldn't be admitting. That being said, there are certain criminal grounds that are waivable. Those are honestly pretty limited. And then there are certain criminal grounds that are not waivable, even for SIJS. And that includes drug trafficking, which is the bane of our existence in immigration law, as well as those terrorism and security related grounds that I think most of us are aware of that are just really tricky to deal with. That being said, this is a baseline SIJS adjustment training. So I'm not going to go further than this into how to deal with criminal and juvenile delinquency matters in the SIJ context, but I do highly recommend the Immigrant Legal Resource Center. They have a number of trainings on this. I think the Children's Immigration Law Academy has a couple of trainings on this as well. If you do have a child who's eligible for SIJS adjustment, please make sure you're getting up to speed on what things are applicable, what things are not, and how best to deal with those. Let me stop for a second and see if we have additional questions. All right, can someone that got SIJS petition for their siblings? Yes, so if somebody has SIJS and they become a lawful permanent resident and then a citizen, if they're otherwise eligible to file a family petition, I think you have to be a U.S. citizen to file a brother or sister petition. They can do that. There's no prohibition on siblings benefiting from someone who got SIJS. It is only on parents. And then this is a really good question from Amber Gonzalez. If SIJS is granted and it's considered parole and they marry a U.S. citizen, can they adjust through the spouse? Our argument is yes. We have a number of cases with different types of family-based petitions that we are starting to move forward. We have not yet had the opportunity to go through full adjudication, but my understanding as well through SIJS practitioners nationally is that that's pretty straightforward. SIJS is parole, and you should be able to use it for other forms of adjustment. Another resource I would recommend to folks is the SIJS listserv, which is SIJS at googlegroups.com, for these types of questions. I do a lot of requests for information from the hive mind, but I think that this should be true. I don't have a particular case right now from NIJC that has reached completion that has proved that USCIS agrees with us, but I do believe there are other folks who recently have. Okay, if a child received a removal order long before the I-360 was filed and approved, is it better to file a motion to reopen based on changed circumstances when the I-360 is approved, or when the priority date is current and they can now adjust? This is a really good question. I think, again, that's probably a judgment call. It's pretty fact-based. It probably also depends on your court, what you know about the judge that issued the removal order. in some ways, I think right now is a good time to file motions to reopen because we don't know what's going to happen next year, right after the election. So I think it's really a judgment call. We have definitely filed motions to reopen based on current eligibility for adjustment, but we've also filed motions to reopen based on just eligibility for SIJS, depending on the other circumstances, right? Often with kids, they have an in absentia order of removal from years ago or from recently because they are not in control of their own ability to get to court. So really fact-based, really a judgment call, but definitely a possibility. Okay, the two resources, again, I think you're talking about the ones for SIJS with criminal or juvenile delinquency, ILRC, Immigrant Legal Resource Center, and Children's Immigration Law Academy. Okay, Andrea is asking, my research found that a prior removal order executed is waivable. We have not, this is a good question. I have not had the opportunity to test this. We don't see a lot of kids who have already been removed and are back, but that is an interesting theory. I look forward to seeing your feedback about your opportunity to test this, Andrea, on AILA Chicago. And then advanced parole for SIJS adjustment. Also have not had the opportunity to test this. I personally get really nervous about advanced parole generally. We don't usually particularly recommend it. One, because our kids are younger, but two, it makes me very nervous. That being said, it's definitely worth looking into, but you'd have to advise your client very, very carefully about that. All right, I'm going to move back to the slides for a minute, and we will try to come back to any additional questions that we may have missed. All right, so the adjustment checklist to file your SIJS-based adjustment, meaning your client has SIJS approved already and a current priority date, and you have carefully assessed them to make sure that they are admissible and they do not have any other issues that would put them in danger of removal by affirmatively filing this adjustment petition, right? You will need a cover letter. Here, the cover letter is going to be a little bit more detailed, right? Because adjustment of status, it's a massive form. There's a lot of factors. You'll want to pretty much tell the story, explaining why they're eligible. You do not, at this point in your cover letter, have to go back and re-explain why they're eligible for SIJS. So we will not be going into details of abuse, abandonment, and neglect in a cover letter unless we are trying to use that as some sort of mitigating evidence for example, a criminal or juvenile delinquency history. You'll use your Form G28, your Form I-485 for adjustment of status, as always, checking the website to make sure you are working with the most recent edition. You will need 2 passport-style photos. I should go back and say this is for an adjustment of status application before USCIS. Adjustment of status can happen before the immigration judge, and in fact, if the child is in removal proceedings currently and they have not been charged as an arriving alien on their NTA, their adjustment will need to either proceed in court before the immigration judge, or their proceedings will need to be terminated for them to file with USCIS. So right now, we're just talking about USCIS adjustment. So your cover letter, your forms, checking to make sure they're the most updated edition, 2 passport-style photos, a birth certificate with a translation. Again, here, if you have an identity document, that is ideal. If you do not, go ahead and submit with your birth certificate. And if you get RFE'd for more evidence of identity, you can proceed with your affidavits, your explanations of why your child may not have that ID document. You'll want your copy of your SIJS approval notice, which establishes that the child has SIJS and also includes the priority date to show that their priority date is current. We always include a copy of the current month's visa bulletin. In theory, USCIS could look that up, but we just want to make it really easy for them. We highlight even the 4th preference section on the little table. And then these days, we do include right away, if we can, that sealed medical exam. The medical exams no longer expire, which is huge, right, for everyone, not just special immigrant juveniles. And so to make this process happen more efficiently, we will have our child obtain that medical exam and we will submit it right away. If it's not available and you do want to get your adjustment application in, I highly recommend you submit the application and you wait for USCIS to send you an RFE before responding with your medical exam. Do not send a medical exam just out into USCIS without any sort of RFE for it, because it can potentially get lost in the ether and you'll never see it again, and your client will have to pay for a new one. That is just a general practice tip. Next slide, please. All right, so if this is applicable to your case, if your client was previously in removal proceedings, you should include a copy of the immigration judge's order terminating those proceedings, right? That will hopefully prevent USCIS from responding by saying, oh, the child is in proceedings and therefore we don't have jurisdiction. And finally, if your client has had any police contact whatsoever, we will be carefully assessing the client for eligibility first, because we do not want to put them in danger of removal if they apply when they're ineligible. And then we will provide copies of any criminal dispositions. If your client has a juvenile delinquency history, again, I highly recommend going to the practice advisories and trainings put on by the ILRC, by CELA, by other experts. But there are very good arguments for not submitting the juvenile delinquency adjudications, even though you will have to answer yes in terms of certain questions on the I-485. And then you'll want an affidavit from the client explaining any rehabilitation or other mitigating factors. As always, you're going to be super careful with this affidavit about any admissions that you might make. You want to really limit it to those mitigating factors. But again, this is not an SIJS AOS with criminal issues training. This is our baseline training. So if you do have these issues in your case, definitely consult with your resources to make sure that you're up to competence before submitting that application. All right, so starting from the very, very beginning, Form G28, it is mostly self-explanatory. Specifically, you're going to make sure that your appearance box is before USCIS, that you have written in Form I-485. Here, the client is the applicant, right? The I-360 is a petition, Form I-485 is an application. This third checkbox is something that we use in clinics for NIJC when we're working with pro bono attorneys. If you're an individual immigration practitioner, it's kind of up to you and your client to determine whether original documents are going to be sent to you as the attorney or to the client directly. But if your client lives in a place where it's difficult to get mail, or their mail gets stolen, or they're about to move, you may want to consider having original documents sent to you. All right, let's go into Form I-485. Okay, so in your first section, it's going to request information about the client. If you have an NIJC pro bono case, we will have reviewed all of this already. You will get a client file with everything you need. Your obligation as a pro bono attorney with NIJC will still be to review all of that carefully with the client to make sure it's still accurate, but you will be handed a packet with all of this. If you are doing this on your own with your individual client, you will need to review your client's immigration documents, their family history, and interview them to make sure you have all of this information. Your A number can be found on the SIJS approval notice, and you're not going to fill out that USCIS only box at the top of the form. You will leave that blank. You will check the box for G28. And mostly we don't have USCIS online accounts already for these individual clients, so we leave those blank. A practice tip is that we are no longer required to put NA on every USCIS form that doesn't apply. So if a question does not apply to your client, please go ahead and leave it blank. Okay, an important piece about this is the Social Security number. This has come up more often now that many of our clients are able to get deferred action and a work permit many years prior to applying for adjustment. What that means is that many of our clients already have a Social Security card and a social. So they will need to check yes, and they will need to put their Social Security number in here, but we will still be checking yes to request a new one with the I-485. And this is because their existing social is almost certainly restricted. So you'll want to verify this with your client. But if, for example, it's based on deferred action or a work permit or some other kind of work permit, it's very likely a restricted social, and we will want to most efficiently try to request that the administration issue a non-restricted social security number, which they will be eligible for once they are approved for lawful permanent residence. Okay, so the immigration history section, there is a whole section on passport information, but you're only going to fill that out if the client had a passport at the time of entry. The whole I-485 is an exercise in carefully reading and rereading the questions because they're often confusing. So the passport information, if your client has a passport now but did not have it at the time of entry, go ahead and leave that blank. Most, again, this information comes from NIJC's clinics. Most of our clients, as children, have entered without admission or parole. Some of them may have entered on visas or in other ways, but you want to make sure that you're carefully checking and entering the correct answer. Most of our clients do not have an I-94, so we'll leave that blank. And the current immigration status on the Form I-485 now is Special Immigrant Juvenile or Approved SIJ, because that's the status they currently have. And then the application type, which is on page 3, I believe, is Special Immigrant Juvenile Form I-360. All right. And then a couple of highlights, because this is a very long form with a lot of questions. We are not applying here under Section 245I. SIJ adjustment is under Section 245A. You will need to fill in the client's receipt number and their priority date, which you will find on the SIJS approval notice. As we talked about before, there are no derivatives in SIJS. So you will leave all the questions about spouses and children who may be applying with you blank, because this petition is not eligible for that. You will need to check with your client about whether they have previously applied for a visa. Usually our clients have not because they came here as children. All right, so here, this is the tricky piece that you may want to work with your client to provide to you ahead of time. You will need their address history and employment history for the past 5 years. Depending on how old the child is and how many times they may have moved, this may be easy or hard to obtain. If, we understand that children may not have all this information, if the full or detailed address isn't available, you can go ahead and list whatever you have, whether that's the town, the district, the province. And if you need more space for those addresses, you will use the addendum. Oh, and then I didn't delete this. The clients don't need to sign and date each addendum page. We will just fill out the addendum for this. Okay, so information about parents, spouses, and children is separate from information about derivatives, right? On pages 5 through 9, they're simply asking about information about those relatives. So you do need to include here all of the children, a spouse if they have one. And I want to point out here that at the time of applying for SIJS, the child must meet the immigration law definition of a child, right? They have to be under 21 and unmarried. But that's at the time of applying for the I-360. USCIS has now clarified that at the time of applying for adjustment of status, the individual no longer has to be under 21 and unmarried. They can move on with their lives in those many years of backlog, and they can get married if they want to. And once again, there's no derivatives. So while you do need to include the information, the answer to, is this a person applying with you? That's always going to be no. And then finally, there is a whole host of really stinkily worded questions about inadmissibility, right? This is the big and difficult piece of Form I-485. It is a pain. Our practice is, however, we need to both read the question verbatim and explain it to the client in relatively simple language. We have a sample sort of precursor to that here. We try to explain to folks, I am asking you these questions. They're going to sound weird. I do have to ask them all of you. let me know if you don't understand. And then we do our best to both explain the question in a way that the client understands, get an informed answer, and read them the question literally so that we can say that we did. If the child marks yes for any of the questions, they will need to provide an answer on the addendum at the end. Depending on the type of question, it may or may not be serious, but these are really important to go through each one and not make assumptions. I will say just little anecdote here. A couple of years ago, I was reviewing a form I-485 with a teenager, and usually, I wouldn't skip over, but like I would pretty quickly go over the questions about, communists and Nazis. And usually I would have to explain to kids what Nazis were. And this 15-year-old told me, oh, I know what Nazis are. They have some at my school. So that is my tragic anecdote, but please don't make any assumptions about what the child may or may not know or may not be able to answer. Okay, some additional highlights about potential answers to these grounds of inadmissibility questions. On question 18, many of our clients were previously in removal proceedings, right? So if so, you will need to check yes to this question. And if you are applying with USCIS, you will say, I was previously in removal proceedings, but they were terminated on whatever date they were terminated on. If your client is currently in removal proceedings, then this is an application you'll need to be submitting to the immigration judge and not to USCIS. Question 23 asks for any applications for relief from removal. This will include SIJS, so you will check yes and explain that the child was granted SIJS on whatever date. And then question 25 is one of those big catch-all arrest questions. This includes arrest and detention for any reason, including by immigration authorities. So if your client has had any immigration contact, you will need to check yes. And anytime you check yes, you will need to provide a brief explanation on the addendum. All right, and I'm going to pause here just for a second to see if we have additional questions based on the grounds of inadmissibility. All right, so I have a couple more questions about derivatives. Someone got a SIJS petition for their siblings. Yes, can a person with an approved I-360 get married and adjust through marriage? I think we answered that above. We believe that SIJS should still act as parole for that purpose. So for the most part, the answer is yes. If a child was included as a derivative in mom's asylum application, was denied and was ordered removed. So for the order of removal, you can still get SIJS even with an order of removal, but if you're proceeding to adjustment of status, you will need to reopen the order of removal in order to apply. So that's something you'll need to deal with before proceeding to the adjustment stage. And then I think I saw another question in the chat. Oh, a couple of them. Is it true that step parents are not included in the no parent provision? So technically you can petition a step parent. I do not have the answer to this question. Can you file a family petition for a step parent, or does the parent have to have adopted you? I'm going to leave that to the side for the moment because I don't practice as much in family law. If you can petition a step parents are not included. It's only biological parents essentially that are included in the provision for SIJS, but I don't think you would then be able to petition for them, but I'll defer to an expert on that. Okay, so you can petition a step parent. So then I believe it says natural or legal parent. So if the step parent has not adopted the child, then they are not a legal parent. But that's a good question. I think it's worth further investigation. Question about leaving blank or putting NA. We're no longer required to put NA on our immigration forms. All right. So let's go back to our grounds of inadmissibility. The public charge question does not apply to special immigrant juveniles. So you can skip this entire section. All right, some additional highlights for our grounds of admissibility. Many clients have entered without admission or parole, and that is fine. You will need to check yes, but it won't bar their adjustment. And then I always point out paying special attention to the wording of questions 78 and 79. Those questions are directed mainly towards bars. They ask about unlawful presence, but they're talking about unlawful presence followed by a departure and reentry. So most of our clients will answer no. If you have a client who is potentially subject to those bars, you may need to answer yes to that question. All right, so we're getting to the end here. As with any adjustment, there are accommodations that can be made for clients with disabilities. You'll need to check with your client. You'll want to make sure that your client understands that they have to file their change of address. And then male applicants between 18 and 26 need to be advised that USCIS can share their information with Selective Service. And then finally, so when working with children, the issue of signatures comes up, right? Each applicant is expected to sign their own I-485. This is on page 17. For kids under 14, parents may sign for them, but they don't have to. We've had kids who are quite young who want to sign their own names on immigration forms, and that is fine. There is no requirement that an adult parent or guardian sign for them if they can sign their own name. But parents have that option to sign for them. If the client is over 14, they must sign for themselves. And then you as the preparer and any interpreter are also required to sign and date. You should pay attention to confirm whether the client has worked in English or whether you've used an interpreter. All right, and then some additional basics about the form. You want to enter your information as a preparer, mark the box that your representation extends beyond the form, if appropriate, depending on your retainer with the client, right? You do not want your client to sign in the signature at interview box. That is only if the client is granted an interview. All right, so where to file Form I-485? This is something else where you always need to check before you send it off because these filing addresses do change kind of regularly. So carefully check. This is as of yesterday was still the filing address for SIJS-based Form I-485s for folks who live in Illinois. Indiana, Wisconsin, other states have different addresses. You will need to check that on the direct filing addresses linked. We do at NIJC have a practice of submitting all government filings via FedEx or service with delivery confirmation, and we keep a full scanned copy of our filing and our delivery receipt. And we have had to, more times than is really reasonable, prove that we sent something because it was lost. So this is really important for any government filing. So we've got our forms. We actually don't have our fees. There is no fee for SIJS-based adjustment of status or any other forms that are based on SIJS, so you will not need to submit a fee waiver or anything else here. It is simply your Form I-485 and associated documents. You need 2 passport-style photos. Don't do this at home. Even like our highest quality ones that we've had clients try with an app or something, a lot of those have gotten rejected. It's not worth it. Figure out how to pay for the Walgreens version. The sealed medical exam, you will want to make sure that you have a copy to review to make sure there's no issues with that sealed medical exam. But what you'll file will simply be the sealed envelope. Do not open this, obviously. And you should either file it at the time of filing together with your I-485 or wait for an RFE. Like I mentioned before, try not to send it separately to USCIS. It's very likely to get lost. And then finally, your supporting evidence will be your government issued photo ID, if you have one, your birth certificate, your SIJS approval notice, and your current visa bulletin showing that the child's priority date is current. If the client has arrests, we've talked about this before, go do your research and make sure that you are making those appropriate arguments, but we're not going to address those here. All right. Here's our final checklist. I just reviewed this, but this is your list. This will be up on our website. You'll see these slides after the training if you need to go back and review. We also have templates for these if that's something that would be helpful in your practice. Oh, here's a good question. As a freelance paralegal, can I do this kind of process for a friend or a client as a preparer? So this is an ethical question, right? I think as in theory, anybody can prepare an application, but there are really big questions about unauthorized practice of law, right? So you can't represent somebody before immigration if you are not a lawyer. The preparer section is a little bit different. I'm not going to go fully into the analysis of this, but I think this is a really good question. It is worth investigating carefully so that you do not practice on law in an unauthorized matter. And let me go back and check my Q&A. Processing time for the I-485. So I don't know what the official processing time is right now. What we have been seeing in the past year or so with our I-485s, what would you say, Bede? Like 6 to 8 months, maybe? Is under
Yeah,
a
around that. There may be delays with USCIS regarding like them losing an application or, submitting RFEs. So yeah, we don't have a concrete date.
Right. And that can vary a lot. So that's a really good thing to talk to your client about ahead of time to make sure you're managing client expectations. I try to be very straightforward and say, like, this is what we're seeing right now. It's definitely subject to change. It's not something that's in our control. Unfortunately, we cannot give you an exact answer about this. That being said, we've provided you a timeline here. This is just based on like our experience in the last like year or so. Typically, we see a receipt notice. It's not really within 2 to 4 weeks lately. It's probably 30 to 60 days now this past year. And then a fingerprint notice shortly after that. Your client will need to get fingerprinted for their Form I-485. And then once USCIS is ready to continue processing your application, if your client is currently eligible, they will issue you an RFE for the medical exam if you didn't submit one. And then the interview process. So here in Illinois, for SIJS cases, I have not seen an interview for an SIJS adjustment in like 5 years. And even before that, I only had one, and it was because of criminal issues. So most often, if we have submitted a complete application and the client is clearly eligible, you will submit your medical exam, and some period of time afterwards, the client will receive their approval notice and their green card in the mail. It's been quite often that simple. Once again, we cannot promise this because USCIS can interview the child if they want to. But this is our typical practice in recent years. All right, Michael Kern says processing times from 41 days to 1.5 years. Yeah, I think that's right. It's subject to change as always, but we have seen a lot in under a year. All right. This is our CLE word number 2. Please write it down, adjustment. Once again, you will receive those slides and this training will be posted. Do we have any additional questions? I'm excited about all of the really good questions that we've gotten throughout this process. Do we have any last questions that folks want to talk about before we end this training? All right. Oh, can you please repeat the IJ name that handles juvenile cases? So in Chicago, the juvenile docket is before Judge Kreitz, and she handles cases of juveniles alone, so not consolidated with an adult up to age 21. Okay.
To We're gonna check the chat for questions as well, if you were not putting them in the Q&A.
Oh, here I'm looking back at some of the earlier questions in the chat. How early can you request termination of removal proceedings? Has anyone succeeded with a filed APR? Yes. Depends on the judge, as you say, Diana Gomez, but we have, in some cases, had success requesting termination simply based on the fact that the child's eligible and we filed the case. And then I think the other ones we have answered. What if the person that is in SAPCR order is an aunt and not a parent? Yes, so a child can file a family petition for someone else who they're eligible to file a family petition for. I don't do family law. I'm sorry, family-based immigration very often. I don't think you can petition for an aunt. But the prohibition is only on parents. And then finally, I said contact Judge Payton and Lynn Hollander for some reason. So our practice has been if we see a child in removal proceedings who should be on the juvenile docket, meaning they're under 21 and they are not consolidated with an adult, those cases, according to the court, should be docketed with the juvenile docket, which is currently presided over by Judge Kreitz. So you can either do that via motion, but just given the volume of motions that are being filed at court right now, I will typically email our motion to Judge Payton, which has been her request, and CC Lynn Hollander, who is the assigned ICE attorney for the juvenile docket, as well as Elizabeth Earlywine. Again, if all of you start emailing Judge Payton about these and she says you have to stop, my apologies in advance. Every time I have emailed her about this, I have said, if you want a different process for this, please let us know. But that's the process that we've been instructed for when we find a case that really needs to be on the juvenile docket. All right. Bere is going to talk to you a little bit about our case list, and then we are going to sign off, I believe, for the day. But we really appreciate everyone's attendance. And we hope that you will take some pro bono cases from us and that you are a little more comfortable now filing SIJS petitions as well as adjustments.
Yeah, thank you so much. Again, I do have a list of predicate orders. You are not required to take a case, but I do appreciate if you take one. You can reach out to me directly. My information is on the presentation, and I will send a follow-up email. Also, do not forget to scan the QR code before you leave the evaluation. This is important so you can get your CLE credit and certificate of participation. If you are in another state, if you're not practicing in Illinois, you can still get the CLE words, and then you can request it in your own state. But if you don't want to do all that, you can get a certificate of participation. So make sure you scan this QR code for the evaluation and put those CLE words. And I will send a follow-up email again with our case list, our materials, and with the QR codes if you're tuning in from a mobile device. All right. And thank you so much, everyone, for joining us.
Thank you, everyone. Bye-bye.